Be ready? Start. Created thereby stop. In this case, as the initial period of lease is for 3 years, extendable for another period of 3 years, the lease agreement executed initially on 11/8/1996 be compulsorily registrable document stop. So it is necessary to verify whether the lease agreement be registered or not. It may also be verified whether the lease agreement has been registered or not. Steno. With regard to point number 3, above it is stated that Dr. Manjula is only having 50% share in flat number 608, but by the will the figure 606 has been corrected as 608 stop. So it may be verified whether Dr. Manjula has executed will in respect of flat number 606 or 608 stop. With regard to point number 4 above, it is stated that in the copy of the will it has been mentioned as do hereby revokes the former wills and codicils if any made be me at any time hereto, and make and declare that this is my last will and testament stop. The fundamental idea of execution of a will is that the testator should dispose of his property or such part thereof as his personal law permits him to bequeath by a will in such manner as seems to him best. Steno. A will is an expressed intention as to what should happen to the property on the death of the testator. A will, though executed by a living person, takes effect only on his death. It should have the characteristics viz. It must be intended to come into effect after the death of the testator, and it must be revocable. If a person executes a document coining it as a will, only indicates that he bequeathed his immovable property to his heir in absolute right, and that is his last will and testament, as the said document has not mentioned that the direction given by him should come into force after his death, or that he is reserving his right to revoke the document at any time before his death. The said document cannot be termed as a will. Steno. The rulings of various courts make the position clear that unless a document satisfies the two characteristics, that is, it must be intended to come into effect after the death of the testator, and it must be revocable, it cannot be treated as a will. A document cannot be treated as a will by a mere reading of the heading of the document. In that view of the matter, after going through the contents of the document said to have been executed as a will by Dr. Manjula, as the said two characteristics are not existing in the said document, it cannot be treated as a will. Over.